Here are what I consider to be the most important bits from the syllabus of the Obergefell v. Hodges decision. To the respondents, it would demean a timeless institution if marriage were extended to same-sex couples. But the petitioners, far from seeking to devalue marriage, seek it for themselves because of their respect and need for its privileges and responsibilities. The fundamental liberties protected by the 14th Amendment's Due Process Clause extend to certain personal choices central to individual dignity and autonomy, including intimate choices defining personal identity and beliefs. I've heard some argue that you don't have a right to marry, but the Supreme Court has long disagreed. Applying these tenets, the court has long held the right to marry is protected by the Constitution. For example, Loving v. Virginia invalidated bans on interracial unions, and Turner v. Safley held that prisoners could not be denied the right to marry. Here is what the court saw as the relevant legal principles and precedents behind their decision. The first premise of this court's relevant precedents is that the right to personal choice regarding marriage is inherent in the concept of individual autonomy. This abiding connection between marriage and liberty is why Loving invalidated interracial marriage bans under the Due Process Clause. Opponents say that there's no right to gay marriage to be found in the Constitution. In actuality, the Constitution says Americans have a right to liberty, and the right to liberty entails the right to marry the consenting partner of your choice. As the court says, the right to marry is a fundamental right inherent in the liberty of the person, and under the Due Process and Equal Protection Clauses of the 14th Amendment, couples of the same sex may not be deprived of that right and that liberty. A second principle in this court's jurisprudence is that the right to marry is fundamental because it supports a two-person union unlike any other in its importance to the committed individuals. The intimate association protected by this right was central to Griswold v. Connecticut, which held the Constitution protects the right of married couples to use contraception, and was acknowledged in Turner. Same-sex couples have the same right as opposite-sex couples to enjoy intimate association, a right extending beyond mere freedom from laws making same-sex intimacy a criminal offense. A third basis for protecting the right to marry is that it safeguards children and families and thus draws meaning from related rights of child-rearing, procreation, and education. See, for example, Pierce v. Society of Sisters. Without the recognition, stability, and predictability marriage offers, children suffer the stigma of knowing their families are somehow lesser. They also suffer the significant material costs of being raised by unmarried parents, relegating to a more difficult and uncertain family life. The marriage laws at issue thus harm and humiliate the children of same-sex couples. So the folks howling "what about the children" are ironically the ones seeking a legal arrangement that places a harmful stigma on the children. The stigma placed upon them by conservatives trying to justify their bigotry by pretending to care about these kids' well-being. But it's also important to remember, this does not mean that the right to marry is less meaningful for those who do not or cannot have children. Precedent protects the right of a married couple not to procreate, so the right to marry cannot be conditioned on the capacity or commitment to procreate. Finally, this court's cases in the nation's traditions make clear that marriage is a keystone of the nation's social order. See Maynard v. Hill. States have contributed to the fundamental character of marriage by placing it at the center of many facets of the legal and social order. There is no difference between same and opposite-sex couples with respect to this principle. Yet same-sex couples are denied the constellation of benefits that the states have linked to marriage, and are consigned to an instability many opposite-sex couples would find intolerable. It is demeaning to lock same-sex couples out of essential institution of the nation's society, for they too may aspire to the transcendent purposes of marriage. Extending marriage to same-sex couples does the opposite of everything that conservatives say it does. They say it demeans marriage when it is actually an expression of respect and admiration for marriage. They say that recognizing same-sex marriage is bad for children when in actuality denying marriage to same-sex couples is bad for children. They say it undermines the family, the fundamental unit of society, when in reality it reinforces and strengthens that unit. Opponents of same-sex marriage are anti-family, anti-children, and anti-social order, yet have the gall to levy those charges on those who truly stand up for families, children, and social stability. These arguments are largely based on the 14th Amendment's Due Process Clause, but the court also argues that same-sex marriage must be recognized according to the Equal Protection Clause. Indeed, recognizing that new insights and societal understandings can reveal unjustified inequality within fundamental institutions that once passed unnoticed and unchallenged, this court has invoked equal protection principles to invalidate laws imposing sex-based inequality on marriage. As I said before, if same-sex marriage is banned, Angelina Jolie is allowed to marry Brad Pitt, but I am not allowed to marry Brad Pitt on account of my sex. This is a form of unjustified sex discrimination. To those who keep whining about unelected judges denying the democratic will of the people, the court says, while the Constitution contemplates that democracy is the appropriate process for change, individuals who are harmed need not await legislative action before asserting a fundamental right. People's rights are not subject to a vote.